I mean, for us, it's really special that we can have these kind of talks, this kind of debates between researchers and high-level scholars. Um, our idea today is to discuss the somehow Solomonic decision by the Oversight Board. My name is Francisco Abreu Duarte. I'm a PhD researcher here at the UI, and I conduct research precisely on platform regulation and digital constitutionalism. And I just wanted to say two words on who's organizing this event and how will proceed in terms of housekeeping rules. So the event is organized by two groups here at the UI, and I'm sort of the bridge or joint venture between both, because I'm part of both. The first is the Digital Public Sphere Working Group, which is a working group exclusively made by researchers who regularly discusses the future of law and technology. The second group is a more formal multidisciplinary group called the Technological Change in Society Cluster. And basically, this group gathers researchers and scholars from economics, law, political science, and history here at the UI to discuss technology in shaping society. And you're more than welcome to join events that we try to organize throughout the year on both groups. And so what we wanted to do today with this event was really to analyze the decision by the Oversight Board on the ban / indefinite suspension of President Trump from the platform, but we wanted to do it really from different angles. And so we know that the Oversight Board is getting more and more academic attention. It was very clear at ICON this week that this is the case, but it poses really many challenging questions from different sides of the law. And of course, these questions range from pure constitutional law debates, use of constitutional principles such as proportionality or the legality, or the constitutional balancing of fundamental rights. There is for sure questions on human rights law and the constant recourse that the body has been making of human rights standards to justify its decisions. But there are also matters of governance, namely the relationship between the board and Facebook, the choice of experts, their independence. And also, and this is why we also invited Mateus, and I'm very eager to listen to Mateus on this. There are purely private law questions or classic private law questions on the meaning and nature of terms of service and the general privatization of digital adjudication. So we really thought that this decision could bind all of these angles together and serve sort of as a catalyzer for a bigger discussion on the Oversight Board. If you agree, we'll proceed in the following manner. Speakers will present their views on the topic for about 15 minutes. And then after all presentations, I think there will be plenty of time for debate. And normally at the Tech Cluster, we really cherish this moment for debate with both researchers and scholars. It's a golden opportunity, I would say, for researchers to ask questions. So please do post questions. Use the chat function throughout the call to write down the questions, and we will try to answer them at the Q&A. Okay, I think this was all I wanted to say in terms of housekeeping. I will now progress to introducing our first speaker, and I can meaningfully say that that classic late night show host catchphrase, my next guest needs no introduction, because Professor Post really needs no introduction. He's a leading scholar on constitutional law and First Amendment rights. He's a Sterling Professor of Law at Yale Law School, where he served as school 16 dean from 2009 until 2017. And before Yale, Professor Post taught at the University of California at Berkeley. And besides being such a great expert on constitutional law and First Amendment rights, he's also a very accomplished legal historian and currently writing, I'm not sure if it is already finished, but currently writing one of the volumes of the Oliver Wendell Holmes devised History of the Supreme Court of the United States. And has, of course, edited numerous books and papers. I would name but two. The first is Democracy, Expertise, and Academic Freedom, a First Amendment Jurisprudence for the Modern State, kind of a Bible for many of us that study First Amendment and freedom of expression. And also a very interesting paper, a very interesting critique on the approach of the Court of Justice of the European Union on Google versus Spain and the right to be forgotten. And I highly recommend that paper just from an European perspective to understand the different meanings of privacy and how the court might have failed actually to fully grasp them. So it's an interesting critique on the Court of Justice approach on Google versus Spain. Finally, with great interest for us today, Robert is a trustee of the Oversight Board and is responsible for safeguarding the independence of the board. And I would say that we could really not ask for a better opening speaker for this conference. Professor Post, it's really an honor to welcome you to the UI today, and the floor is yours for your presentation.
Thank you, Francisco. It's overwhelming, and I'm most honored to be here. I should say, by the way, in terms of your reference to a Bible, this 1 a.m. panel that I was on at ICON was on blasphemy. So there you are. Okay, so I should say at the beginning, I'm a trustee of the Oversight Board, Facebook Oversight Board. I'm not a board member. I don't make the decisions. I'm not involved in the decision making, but I'm a trustee. And in a few minutes, I'll describe the difference between trustees and board members. But I need to make a disclaimer at the outset that everything I say now will be in my personal capacity as a scholar, as someone who thinks about these issues and wants to understand them. I'm not in any way speaking for the board in any official capacity. And this also means that I won't be able to say very much of any interest on the recent lawsuit filed by Trump to change Facebook's policy. So those are areas I have to stay away from. So because of the obvious constraints on what I can and can't say, I thought I would my contribution on this panel would best be made by stepping back and framing the issues that we should be thinking about when we try to understand from a scholarly research capacity what the function is of the Oversight Board, why it was created, the challenges that it faces in regulating speech over Facebook. And so I want to start with two major developments in the law of communication, which set the scene for the creation of the Oversight Board. The first is the invention of the internet. I don't think there are very many people on this call who were around and working before the internet arrived on the scene. But I can remember very distinctly in 1990, when I got my, when we first connected to the internet, at that time you had to do it through your telephone line. You called up on a modem and it went up on the telephone line. And I can remember very distinctly a colleague coming over and looking at my computer. And at that point, the computers had, the blinking cursors. That's what it was, like kind of DOS computer. And saying to me, why do you need to connect to the internet? It just tells you what you already know. I mean, what's the point of this thing anyway? Very distinctly, 1993. So the internet has arrived. It has changed everything. It has created forms of communication that are entirely new in human history. And I want to mention two, because both of those have great relevance in understanding what we're about to discuss. The first is that the internet distributes information with virtually zero marginal cost. And that means information races everywhere on the internet, and it raises issues of scale and virality, which are new in human history. So it's one thing to say that a statement, you can tolerate a statement by a speaker on a corner at Hyde Park when there are 5 people listening. It's quite another when there are 60 million people listening to a statement, and an virtually infinite number of people can access the information. A second consequence of the zero information cost is that information now is everywhere. Everyone has access to it. And the only communicative innovation that I can think of that's even roughly analogous in the profundity of its impact is the development of the printing press in the 16th and 17th centuries. And what that did is it provided access to information to people who didn't have it before. And in particular, what happened in Europe was that before the invention of the printing press, the church forbade you from reading the gospel. So that means the epistemic authority of the priest was he had read the words of Jesus, and he could tell you authoritatively what it meant to get into heaven and what the Bible meant. And after the invention of the printing press, because Bibles were now distributed and they were translated into the common tongue, everyone could read the New Testament. Everyone could read the words of Jesus. And that destroys the epistemic authority of the Catholic Church, leads to the Reformation, leads to a century and a half of war within Europe, because once you destroy epistemic authority, you destroy one of the cements of the social order. And we are in the process of the same thing happening. I've told this story before, but when my sister goes to a doctor now, she looks up all her symptoms on the internet, on Google, and she goes to the doctor and she tells the doctor what, what the diagnosis should be. I have seen now signs in doctors' offices saying your Google search is not equivalent to my medical degree. But if you generalize that over a whole range of expertise, you will see that expertise has become unstrung by the zero marginal information cost of the internet. And one of the consequences, I think, of that has been the rise of an anti-expertise populism, which is very deep all over the world. Because now people think they have access to the same information that experts have, and the epistemic forms of authority by which we have governed our society, complex society, are in the process of being unstrung. Another consequence of the zero marginal information cost is that scarcity is no longer attaches to information. Scarcity is now in attention, not information. And that leads to forms of communication that are oriented toward gaining attention, which may not be the most constructive forms of communication, but they are the ones that are incentivized now in a world where everyone can have information, but attention is scarce. And finally, another consequence, which is extremely important, is that most of us now live in the virtual world. We carry around our phones, we live through the virtual reality created by the internet. And that means that the virtual public sphere has an impact on our lives, which is almost unprecedented in the relationship between a public sphere, and we're going to do some work with the word public, and the living of ordinary day-to-day Lebenswelt, ordinary life. And this is a very important consequence of the zero marginal information cost. So that's one innovation of the internet. A second innovation of the internet is that it's interactive. Before that, if we talk about the traditional public sphere, a broadcaster spoke to the audience, a novelist spoke to the audience, but the audience didn't speak back. So the interactivity of the internet has led to completely new forms of association, new forms of social solidarity. And I think in part, this underlies new forms of polarization, this underlies new forms of balkanization. A second consequence of the interactivity of the internet is that the audience is now visible to the speaker in ways that the audience was never visible to the speaker. And this raises issues of data privacy, to which Francisco alluded before in cases like Google Spain and in the GDPR. A third implication of this is that these forms of solidarity are carried out in an environment which is freed from the constraints of local civility rules. So that the forms of solidarity now are costless, they are cosmopolitan, and that means that people act in the internet and they speak in the internet in ways which are, my mother would say, wash your mouth out with soap. I don't know whether many of you read the comments, but they're virtually unreadable in most things. Why is that? That has to do with the forms of sociality which are created by the interactivity of the internet. And we have to deal with that when we talk about regulating the internet. Now, if the internet raises a host of new problems of regulation, so do new social formations on the internet. And here I want to talk about the social media platforms like Twitter and Google and Facebook. These are totally new social formations, and we do not have the legal categories we need to have in order to understand them. What we're in the middle of now is debates about how to characterize these platforms. And to give you an example of how profound these debates are, here are two entirely opposite characterizations, both of which are quite prominent, at least in the United States, and I suspect in the world, about how to characterize, say, a social media platform like Twitter or Facebook. So I'm not now going to speak the language of markets and antitrust, but it's plain that these social media platforms, Twitter or Facebook or Google, YouTube, dominate certain forms of interaction, social communication on the internet. And because they exercise such great control over these forms of interaction, and their power comes, of course, from the network effects, which is you want to be involved in one of these platforms because it gives you access to so many people, and the value is added as more persons instead of costs. Value goes up as more users are involved, and so because they're dominating, there are many people who take the position that these platforms should be considered like the state, In the US terms, you would say state action. In countries which have horizontal effect, this is of less importance. In countries which require state actions for constitutional constraints to apply, this is of immense importance. And so the claim is, and this is the claim that Trump has raised in his recent lawsuit, that these social media platforms are the equivalent of the state and therefore are subject to constitutional restrictions in how they can regulate speech, the same constitutional restrictions that apply to government itself. That's one way of legally characterizing the nature of these platforms. And that would mean, and of course, the constitutional restrictions on the platforms would vary jurisdiction by jurisdiction. But in the United States, because we have a very strict First Amendment, it would mean that Facebook or Twitter cannot exercise any content moderation on their platforms. They would be what in the United States we would call a common carrier. It's like a telephone wire. The telephone company doesn't determine what you're saying and content moderate what you say on the telephone. It has to carry all signals. Same would be true of the social media platform. So we analogize them to that. Or in constitutional terms, the social media platforms would be analogized to what's called a public forum. The platforms, in other words, would not be themselves speakers. They would be the carriers for the voice of others. They would be the vehicles by which others speak. They are not themselves speakers. So that's one characterization. An entirely opposite characterization is that the platforms are speakers, and therefore they're immune from regulation by the state in the way that any speaker would be immune from regulation by the state. And the analogy here would be that the platform is like the editor of a newspaper. So what does the editor of a newspaper do? The editor of a newspaper curates the views of others, packages them together, and sells them as a package to the reader. And each of the social media platforms curates what can be said on their platform, and they do this by having community standards, which says, what you can and can't say on my platform, which in turn determines the experience of using the platform. And it does this in ways which, of course, the state could never do. The state could never curate what is said by a common carrier or by a public forum. But because the platforms are speakers, they're like editors, they curate the content and they sell the content to the audience. And if they don't like that content, they can take a different platform. Just like if I don't like the content of the New York Times, I can instead take the Washington Post. So on this picture, the state is disabled from regulating the speech of the platforms. And that speech consists of precisely engaging in forms of content moderation for those who want to use the platforms. And I would say in the United States, at least, that's the dominant picture of the way we conceive these social media platforms. But notice that it's at 180 degrees opposite from the other idea of these platforms. And that's telling us that there's a very deep debate going on now in the realm of legal metaphor, namely, what image do we want to attach to these social platforms? Notice that each of these images that I put on the table for you has very serious drawbacks. So it is the case that these media platforms are for-profit corporations, and it is the case that they exercise a great deal of control over what can be said and not said over the forms of interactions which characterize each of the platforms. And it is also the case that there are important reasons to be concerned when a for-profit company, whose motivations are in the end returning value to its shareholders, dominate forms of communication, which in turn dominate the virtual public sphere, which in turn is so important to all of us. So there are very important concerns there, which are captured by the state model. But on the other hand, if we take the model that they are government, it means that the social media platforms are basically disabled from regulating the speech of their users. And that means we know from the sociality, which is encouraged on the internet, it would turn most of the speech on these platforms into sewers of misinformation and abuse and harassment and all the nasty stuff that happens on internet speech. So each of these images has attractions, and each of them has very deep negatives associated with it. So it is that frame, it is that dilemma which leads to the creation of the Facebook Oversight Board, which is an attempt to avoid, on the one hand, the Scylla of public forum status, and on the other hand, the Charybdis of unfettered private power. The Facebook Oversight Board is an innovation, it's an experiment that's designed to somehow get the best of both of those worlds. And the basic thought behind the Oversight Board is that a private for-profit company like Facebook voluntarily gives up the discretion to moderate content on its own platform to an independent body that is charged to oversee the regulation of speech by implementing public-facing public law values. That's the theory behind the Oversight Board. And it requires Facebook simultaneously to abjure its status as a private speaker in some ways, and at the same, and therefore some of its ability to regulate speech on its platform, and on the other hand, to discipline itself by voluntarily giving authority and power to an independent body. And of course, this compromise requires us to rethink basic legal categories. So it requires Facebook as a private for-profit company to give up the discretion to take a lot of different kinds of actions. So how does Facebook do that and yet maintain its fiduciary responsibility to its shareholders under Delaware corporations law? This is a problem that has to be worked out in the corporate law that governs social media platforms. And one has to be able to do this in a way that doesn't violate basic private law understandings of what constitutes the obligations and responsibilities of a for-profit corporation. And on the other hand, it means that for this compromise to work, the Oversight Board has to be seen by the world, and in particular, the world of users of Facebook, as convincingly independent of Facebook and as convincingly attached to the implementation of public law values. So how does that happen? So I'm not a corporate law expert. I don't do corporate law, so I'm not going to speak to the first of these dilemmas. I'll leave that to those of you who know corporate law better than I do, but I can speak a little bit to the second, which is how the Oversight Board imagines that it's going to give a convincing signal to Facebook users that it is independent and that it is committed to these public law values. And so that accounts for the rather elaborate structure and innovative structure. We're all trying to figure out how it works of the Oversight Board itself. So as Francisco pointed out to you, there's a trust and there's a board. I'm a member of the trust. And what the trust is that Facebook gives an irrevocable grant. It gave us 140 million to get the Oversight Board started. And as a trust member, I am not accountable to Facebook. I'm accountable only to the mission of the trust. So I'm a trustee. And then the trust creates an LLC, a corporation, which in turn creates the board. And the board members, these are the figures who actually make the decisions, are independent contractors to the LLC. And the board itself doesn't have legal personality because it consists of a set of independent contractors. And yet the board, even though it lacks independent legal personality, is the locus of decision-making power and of independence. And in the selection of the board members, one has to give the signal that these are substantial independent people who have values which are different than the profit-making capacity of Facebook, and that are committed to the public values of the enterprise, which is to enforce through rule of law methods the community values that Facebook, the community standards that Facebook itself has promulgated. So the commitment that Facebook makes, and this is only a contractual commitment, it can't be anything else, is to be bound by the decisions of the Oversight Board in particular cases. That is to say, whether a post stays up or whether it goes down. Now, if you think about that for a second, you know that there are millions and millions and millions of posts on any given day on Facebook. And so the question of whether any post goes up or down is, not of great significance. What is of significance is why the post stays up and goes down, which means what is of significance are the principles used by the board to determine whether a particular post goes up and goes down. And the Oversight Board will succeed if it can convince the users of Facebook that these principles are now being honored in a rule of law way. That is to say, like cases are being treated alike, that Facebook is incorporating these values. Now, if you think about that for a second, it's telling you something very deep, which is that the model of the Oversight Board can't be a human rights tribunal. Human rights tribunals give decisions and they say, this is the right decision, and they walk away. The Oversight Board, the task of the Oversight Board is to change the experience of the users of Facebook, which means it has to have a very a certain kind of relationship to Facebook to get it to implement the kinds of principles and values which the oversight board says have to be determining what should be, what are the standards by which we protect or disable speech, content moderate on Facebook. Now, there is a scholarship of this kind of understanding of what a tribunal is. In the United States, it's called the public law model of adjudication. It's associated with people like Abe Shays and Owen Fiss and Judith Resnick, and it requires a very particular way that a court relates to an institution whose behavior it's trying to shape and reform. And to my way of thinking, this is the literature that is most relevant to the success or failure of the oversight board. And so the issue is less the particular standard than the implementation of the standard according to public law values. So a couple of things to notice about this, and then I'll stop talking. I had a lot more to say, but I can see my time is running out. So I'm going to say first, under this model, the way it's set up now, Facebook retains control over the substantive standards which are applied by the oversight board. These are called community standards. This isn't a necessary part of the process. It's up to Facebook whether it wants to give up that role. You know, who knows what the future will bring. I want to talk about that. But under the present system, Facebook delegates to the oversight board the interpretation of those standards and the implementation and the procedures by which those standards will be implemented. That's a huge, so it's a little bit like the relationship between a legislature and a court. The court takes over the job of interpreting legislative meaning, and then determining how that legislation is to be operationalized. It's a cross from this perspective between a court and an agency. There's something in between that we need to sort of think about very hard about what model we want to make for the oversight board on this account. Some people say, well, Facebook retains control over the content. What is the substantive standard? What is it given away? And the answer is that the oversight board is charged with being able to say that content standard community standard is bad. You ought to have this, or you ought to modify it in this sort of way. And Facebook is obligated to respond in public. So what that creates is a public dialogue between Facebook and the oversight board on the nature of the substantive standards to be applied. And that means that Facebook must negotiate this in the full glare of publicity. And if you think about what sanctions can be brought to bear on Facebook, the main sanction that can be brought to bear is the goodwill of customers. And once you put that dialogue in the open, that's the force that's being brought to bear. That's the leverage that the oversight board has on Facebook in order to implement. It has to make recommendations which will earn the trust of Facebook users. And if it has that trust, Facebook risks betraying it if it disagrees with the oversight board. That's the logic by which because otherwise, you know, what obligations would Facebook, how do you actually enforce the affirmative obligations? So that's one thing to notice about this. The second thing to notice about this is that the success of the oversight board is going to be measured by two factors. The first is that Facebook users recognize and trust the signal that the board sends that it's committed to rule of law values, that it's committed to freedom of speech and human rights, because the board is charged with interpreting the community standards in light of human rights. And that's a very important thing to understand, because the board is international. And it has to have legitimacy for more than 3 billion users throughout the world. And there is no legal standard which carries over 3 billion people. So what do we have to legitimate ourselves? What are the resources? The only resource we have available is human rights law. And so that becomes a very important legitimating factor in the interpretation and the operation of the board. So it has to act in a way that sends a credible signal that these matter to the Facebook user and to the Facebook's regulation of the users. And second, because the oversight board is a very expensive proposition, and because at this point it's supported only by money which Facebook has put into the kitty, who knows whether in the future it becomes, you know, expands jurisdiction and other platforms put in money. Again, that's future. We don't know what's going to happen there. But at the moment, Facebook supports it. Why does Facebook support it? A for-profit company? It must believe that it's in its interest to do that. Why is it in its interest? It's in its interest because it's improving its goodwill with its customers. And it's taking away from Facebook decisions, which are, from Facebook's point of view, no win. Those of you who know Keith Whittington and his work on the development of judicial review, he asked the question, why does Congress and the President of the United States give away such vast powers of judicial review to a court? The answer is because you want to give away decisions for which you can't win. No-win decisions. You want to give it to it. You want to kick it down the road to a different institution. That's what Facebook is doing with the Oversight Board. And so long as Facebook perceives that the Oversight Board adds value to Facebook by making the hard decisions, and by improving the experience of its users, we can expect it to continue to support it. So those are the two metrics of success by which this new experiment will succeed. So I'll just stop there.
Thank you very much, Professor Post. This was, I think, a fantastic framing of the evolution of the public sphere. You took us from the birth of the internet, the way we communicate, and how it has changed through the recent regulatory debates, and then finally to the Oversight Board. And that's just the perfect way to introduce the remaining speakers in this session. So thank you very much for that. So my next speaker is I would say one of the most famous scholars working on Facebook's Oversight Board. I think this is an objective comment, although it's also subjective, but it is an objective comment. Professor Kate Klonick holds an AB with honors from Brown University, where she studied both American history and cognitive neuroscience. She holds a JD from Georgetown University Law Center. And of course, because this is a very Yale Law School dominated panel, she is a PhD scholar from Yale Law School and also resident fellow at the Information Society Project. She famously conducted field work on the making of Facebook's Oversight Board, in which Kate spent some time at Facebook's premises, accompanying the creation of the board from, I would say, its very beginning. And I'm sure these references will be discussed throughout this session. Kate has written numerous pieces on free speech and First Amendment, and I would say it's the author of the leading paper on Facebook's Oversight Board entitled "The Facebook Oversight Board: Creating an Independent Institution to Adjudicate Online Free Expression," published in the Yale Law Journal in 2020. Kate, thank you so much for accepting to join us today. It's really a pleasure to welcome you to the UI and to learn from your experience. The floor is yours.
Thank you so much for that introduction. That was lovely. And I honestly, the pleasure is mine. I learn so much every time I'm on a panel with Matuz and Robert, and this is just going to be wonderful. So I want to add one comment to Robert's list of legal metaphors that I think is maybe one of the most interesting and well-fitting, but also the most dangerous. As he said, many of these metaphors have things, which is public accommodation. And I think that is one that has always stuck out to me. And I've talked about that since I did my dissertation, of kind of this idea of like, let's think about this in terms of public accommodation. But the reason I abandoned that approach and that metaphor, and that I think that it has purchase, and why it's coming around again, most recently in Justice Thomas's dissent in the recent Knight Columbia case, was basically that it gets us to a very dangerous place in terms of state regulating private spaces that are also public in some way. These public-private distinction that Robert kind of talked about so well, about the virtual public space versus the actual public space, about being in the virtual public space that is run by private companies while being in an actual public space. And so all of these things are interlocking, and I think that we have a pretty ossified concept of public-private that we are having to complicate for the purposes of the internet and this new world that we're in, and all of these kind of flaws that have been revealed by the internet. And I will say also network technology, that it's not just the internet. It has been the reason this is suddenly accelerated in the public dialogue and in public attention is because we have high-speed internet now, and everyone can carry the internet with them constantly and be on the internet. And it has gone from the days of the blinking cursor and a room filled with like a computer that filled a room to this, like, to this, which is just like a really miraculous kind of moment for connectivity, that really kind of on the curve, it was just like an exponential growth. And so let me think about where I think that we should kind of go next with this, because I'm trying to think. Oh, oh. I think that what I will pivot to is kind of, and what I think my value add most of all, hopefully, to this conversation is what I observed in the early formation of how Facebook thought about setting up this board, and what the process around that was. And as much as I can, I was just one person observing, like, over a series of months, this process. So it's not like, I mean, I was one of the only outside people, but it was, you know, one of the things that you have to always think about when you're doing field work, or you're doing qualitative empirical work, is that you are there are complicated conflicts. There is a reason they let Facebook let me in, of course. Like, they had to be getting something out of my being there and writing about what the oversight board was doing. And there is also kind of the question of, what were they showing me? Were they showing me the whole picture, and how were they showing it to me over time? And so one of the best ways to combat the latter kind of methodological challenge is to just be there constantly and to kind of, as I say, like the Jane Goodall approach. It's like, after a while they forget you're not one of the monkeys. And so I think that was more or less like how I kind of approached this. And the other was to kind of be constantly bringing the observations that I had to other people that were not privy to those moments, and try to relay what was going on, and then kind of talk to Robert, or talk to Jack Balkin, or talk to whoever it was that I was speaking to, talk to a lot of like trusted people, talk to legal philosophers, talk to people who did different models of governance and adjudication, and present and present and present. And that ended up being really, I think, leading me, like, kind of protecting the empirical work that I was doing from, as much as I could, from kind of the taint of being embedded in an organization. But that said, one of the things that happened over and over and over again, and I presented as I did the empirical research around the world. I think I did 32 presentations in 6 different countries, to various groups, from like places like Data and Society, to the Hans Brito Institute, to London School of Economics, to the New York Times. And there were all of these kind of moments. Everyone had different kind of questions, but the first was kind of like, is the board going to have teeth? Is this going to be a real thing? And so this is kind of a very interesting thing to now look back at in hindsight, because these were some of the big questions. And one of the downsides of writing the piece so early, but I mean also kind of important, was that, like, I couldn't answer the questions of what was going to be important. I just could present exactly as the board was launched, this kind of crystallized moment of what people were wondering. And so, was it going to be, and the other that was closely tied into, like, is it going to be independent, and is it going to basically have legitimacy? And I went down a wormhole of legitimacy theory and all of these things, and tried to figure out all of these things. And eventually I kind of just came to the conclusion that Robert so well summarized, which was that it is a thing that develops with time. You can only kind of watch and see what the board does. There was no way to predict any of these things. I can just present the questions that people had, how Facebook responded to them, but then, and call out the factors that were going to end up either creating, either damning the board, or helping the board to excel. And Robert kind of summarized those beautifully. But I want to talk about how the Trump decision in particular, because I can talk about this, how the Trump decision in particular, I think, did a wonderful job in moving the board forward for the purposes of legitimacy. And I want to say, like, something really quickly. Sometimes I get criticized, and I'm not like being defensive about this. I think it's a fair criticism of being kind of pro the board or pro Facebook or something like that. And I'm not pro the board. One of the things that, as Robert said, is summarized, one of the ways to regulate or try to exert control as a public over these massive private corporations that are controlling our public rights, is to take power from them through democratization of the companies themselves, through the imposition of a type of democratic or a type of participatory or a type of adjudicatory model of creating some type of reckoning and putting those institutions or those kind of processes into the corporation's DNA. And instead of it being kind of instead of it being a top-down kind of regulatory approach, that you start to institute like these procedures and transparency from within the company. One of the parts about that was like that like I really loved about the Oversight Board was that that's kind of the model that the Oversight Board came into existence to try to, in theory, in its best kind of most like idealistic aims, came in to kind of like to adopt. And the question was how rich that was going to be. And one of the things that that I saw the least part of, which was the naming of who was going to be on the board, which of course was going to be one of the most important parts of how all of this ended up taking place and how it ended up being ended up shaking out. Basically, like, was this going to be a group of people who were going to take some checks from Facebook, like from the trustees, and who gave it, which Facebook gave to the trustees in this irrevocable grant, and then go on their merry way and issue like some like quick decisions and whatever else? Were they going to take these questions of free speech really seriously? Were they going to take their independence really seriously? When they started telling me who the board members were going to be, I was very optimistic that this was going to be a serious institution. And there's two reasons for that. One is that the individuals they selected had massive reputations themselves, massive, very serious reputations, that they were not going to just kind of decide not to deliver on this premise and to phone it in, basically. They were also not going to, in terms of independence, they were also just not going to want to ever be seen or tarnish the reputations by being seen as being in the pocket of Facebook. That was just absolutely not something any of these types of individuals, they were all serious legal scholars or politicians or academics, and this was just not what a lot of I could see for most of the people that were involved. And the real thing was going to be how much time and energy were these very fancy, very smart people going to have to put into the institution building that was massive to create this board, to put into everything from like how they're going to accept outside submissions on kind of like a amici kind of basis, to how they were going to actually start authoring opinions, what format those opinions were going to have, whether there would be dissents. All of these things have been left open for purposes of independence to the board to decide, and they all had trade-offs. And there was a lot of kind of questions about how all of this was going to kind of shake out once the board started. And on top of that, they had really hard questions that they were being asked. Very, very, very hard questions that they were being asked. And so I would say that the first couple of decisions I was very optimistic about, but the reason I found the Trump decision so wonderful is mostly because I think there was a question. So Robert put it in a much more eloquent form, but I will put it in the form of Hitchhiker's Guide to the Galaxy, which is the somebody else's problem field, that everyone wants an SEP field, because an SEP field means that like you can just divert something, like, oh, like how are we going to create a set of codes that is going to map onto time zones? Well, we just have like we have a thing for that. And everyone points to that. And that's, that solves the problem. It makes it somebody else's problem, right? And like the Unicode Consortium is basically somebody else's problem field in a sense. There's a lot of these in tech. And for Facebook, the Oversight Board, I think one of the most impotent things it could be is just somebody else's problem field and not a conversation between Facebook and between Facebook and the board, which in some ways is a proxy for the public. And so the Trump decision, in my opinion, was very much kind of like took the directive of the board, and to put it in like US administrative law terms, it took the directive of the board and it said, it was basically the equivalent of the Social Security Administration saying, should we give this 72-year-old Social Security benefits, or this like 62-year-old Social Security benefits? Tell us what to do with this. And the district court or the DC circuit coming back to them and saying, no, that's not our job. Like, you tell us what the standards are for how you're going to adjudicate what, or decide what, who gets benefits, and we'll tell you whether you've met the standards in applying them in this instance. And we're not going to set the standards for you. And you haven't given us a decision of setting these standards. You've made a bunch of kind of ad hoc decisions and you haven't applied them consistently. And for me, this was just such a serious approach. It created a very iterative long-term model that we can have. It like laid some groundwork of basically being able to say that we're not going to start setting these rules for you and deciding these substantive issues for you. We're going to make you create procedures and start to apply your procedures to yourself. And that is a much more high level, valuable tool for governance than just another random body of people creating standards that we're all kind of beholden to. It's a dialogue, it's a conversation, it sets up things that can change in the long term, that can be nimbler than maybe what we currently have, certainly more transparent. And so that was kind of the very optimistic piece that I took out of the Trump decision from the Oversight Board. And they did, it looks like Facebook's adopting a lot of the suggestions of the board and kind of they feel like now they made like they were like, you're off the platform for 2 years. That's going to be, and I think that this is a fascinating kind of, I think that these are like fascinating things that are going to start creating some norms around what proportionality is in speech in the online public speech space, that are just so much more that we've been thirsty for the lack of a better term, as a public. And so I will leave it there. But I'm very interested to hear the rest of this panel, and thank you so much for having me.
Thank you, Kate, for a fantastic presentation. I really enjoyed this idea that somehow the Trump decision might promote legitimacy of the board, in the sense that they take a stand and they say, well, this is not our job. Defining standards is your job. So we're not doing that for you. And I think it goes back to Robert's point of, there is this kind of connection between legislation and the legislator and a court or an agency, and those jobs maybe should be separated. So it's not for them to say that. So I find that very interesting. The second idea you said, which I find also really interesting, is this kind of democratization from the inside. And I really would like to explore that idea in the Q&A if we have time, because I think that's such a rich idea, but a very complex one, and there's some pitfalls, I think, there. But let's leave that for the Q&A. Thanks a lot. So my next speaker is also a reference of constitutional pluralism and EU law, and also a good friend of the UI, I might say. Professor Praj Maduro is a part-time professor and former director of the School of Transnational Governance here at the UI. He's also a chair of the novel executive board for the European Digital Media Observatory, which is a new fantastic body. It's originally an SDG-led project. Its main objective is to fight disinformation. Miguel is not only a leading scholar on constitutional pluralism and EU law, but also held high-standing offices in Portugal from 2013 to 2015. Miguel Maduro was Minister Deputy to the Prime Minister and Minister for Regional Development in Portugal, and I would say famously served as Advocate General at the European Court of Justice between 2003 and 2009. Because of course, this is again a Yale Law School dominated panel, and it was partly my fault, or totally my fault. Miguel is also a regular visiting professor at Yale Law School, the College of Europe, and also Catholic University in Portugal. Professor Maduro has published numerous articles on EU law. I would maybe just nominate his latest work on democracy and COVID-19, because there is also a chapter on the future of democracy, including digital democracy. So Professor Maduro, it's really a pleasure to welcome you back to the UI for this session, and the floor is yours.
Thanks, Francisco, and thanks for that presentation. Can only go down after that. I will try at least that the descent will not be as steep as you might fear. Thank you very much, and it's a great pleasure to be in the panel, particularly people I greatly admire, like Robert. I will go more from the specifics to the general. I basically will address 3 questions. And my starting point has to do with something that Robert mentioned. I mean, what's the reason for the creation of the Oversight Board? What can we assume to be the reason of Facebook? And I think that the discussion about that reason tells us a lot already about the issues that the Oversight Board generates. I think that we can see in the creation of the Oversight Board by Facebook an attempt to simultaneously legitimate and transfer part of its role as a content curator, as editor of content. And the reason for Facebook to do that, in my view, is twofold. One is, that was stressed by Robert, is to maintain the trust of its users or its clients, whatever we want to see it. But the other one, I think, it's also a strategic reason in terms of trying to shield itself from the prospect of public regulation. I think that the risks of public regulation led Facebook to proactively take measures. Now, these 2 questions immediately highlight for a variety of tensions on what exactly will be the role of the board, and therefore how should we assess its legitimacy, but also what actually should be the consequences in terms of public regulators and courts, for example, in living with this initiative of Facebook. And so my 3 questions express that. The first one is, to which extent can we expect the board to fulfill that expectation of legitimacy in light of how it's set up? And it's true that a lot of it will depend on what exactly the board will do, and it's only at the beginning. And I think that I also tend to agree that the way they decided the Trump decision is one that enhances their legitimacy. But I also think that, all things considered, it was one of the easier decisions for them to take. And I think I'm curious to see how they will decide the Al Jazeera case, that I think is susceptible to much more controversy. And it will be when they will have to take a decision on cases that are likely to generate a lot of public controversy, that we will see how they will be able to establish or not their legitimacy. But we can also assess that already at the level of their institutional design. And the first question there is attention, and I will deal with this again later on. It's attention on whether exactly, I mean, my first approach to it was, can we see in the way that it's institutionally designed and set up as respecting principles of due process and independence that you will expect a judicial body or a quasi-judicial body to respect? And that seems to have been the aim, the target. If you look at how it is developed in a lot of ways, it seems indeed, and Kate also, I think, highlighted that it seems that wanted to be the target. But at the same time, it seems that it has a role to whereby the standard will not exactly be the same as almost as a regulator, because it's given it a role of policy advisor. And so one of the things I will come back to this is a possible tension that exists on the role of the Oversight Board between being an adjudicator and a reviewer, almost judicial reviewer of decisions, or being a policy maker through its policy recommendation rules, and the extent to which that may lead to tensions in the future. Now, the second question I will address is is whether legislators and courts should take into account the setting up by Facebook of a mechanism and an institution such as the Oversight Board in terms of how they will in turn exercise both their roles of public regulators or judicial adjudicators in cases involving Facebook. That is, should they defer to platform decisions on content in light of the fact that Facebook has created an institution such as this? Should the fact that Facebook has created an institution such as the Oversight Board lead to a different standard of judicial review, for example, or lead public regulators to take a different approach on how they regulate Facebook or platforms in general? And this will be increasingly important in light of the tendency, at least in some states, on some legal regimes, but particularly the case with the European Union, with the Single Digital Act, that tends clearly to lead to deal with platforms as in the attempts, at least, or will attempt to deal with digital platforms in the same way that you deal with offline editors of content. That is the logic behind the Digital Single Act. And there's a famous statement there. What is not possible offline should not be possible online. It's a mantra of the Digital Single Act. And of course, that means that we should expect more regulation, more on platforms. Should this regulation or the rules that courts will have incorporate, and in which way, the fact that platforms developed institutional mechanisms such as the Oversight Board? And that will be the second question that I will address. And the third one is, should this approach that Facebook developed actually be transferred, taken up by the legislators and regulators and imposed on platforms? Should it be a way of regulating to actually start requiring from digital platforms to developing institutional mechanisms similar to the Oversight Board that Facebook? Can actually that be one of the regulatory models for the future of regulation digital platforms? So that's the third question that I will address. And so, as I said, I'll go from the more specific to the broader. Now, as to the standard, or whether or not the Oversight Board fits in terms of its rules and institutional design, standards of due process, and similar to judicial independence, I think that the most interesting similar case to what Facebook attempted to do or attempts to do with the Oversight Board is what happens in the sports jurisdiction, that, as some of you know, I love to use as an example, and it's very, very similar. This is something similar to what FIFA and the International Olympic Committee tried to do with the Court of Arbitration for Sports, that is simultaneously a way to provide judicial remedies in areas where they de facto exercise regulatory powers, but at the same time of creating a reason and a justification not to be subject to ordinary courts. Now, there is a big difference, and it's a very, very relevant difference between the two systems. The Court of Arbitration for Sports is de facto mandatory and exclusive. Sports athletes, everybody in sports is not authorized to have recourse to ordinary courts. That's not the case with the Facebook Oversight Board. So you can, if you want, you don't even need to appeal to them. You can appeal to regular jurisdictions and go through the ordinary court system. So that's a really important difference. While in fact CAS, even if the CAS clause, jurisdiction clause, is legally voluntary, as the European Court of Human Rights has already established and decided, it is de facto mandatory because athletes have no other option if they want to exercise their job but to accept the jurisdiction. And of course, there's also public order exceptions that leads courts to intervene in some instances, but that's an exception. So that's an important difference. But there is parallels in many other ways. First, both deal with transnational private entities that have non-statal regulatory authority that collectively regulate behavior de facto. Both are instances of that, and both boards and the Oversight Board and CAS deal with that. Second, both regard specialized areas that may benefit from expert knowledge and specialized knowledge, and we see that in the bylaws and all the justification for the Oversight Board and for example the criteria for selecting the members of the board that is stressed several times, as it is, by the way, in the case of CAS. Third, in both areas, you can say that there is potential and institutional comparative advantage for these bodies with respect to traditional judicial bodies and ordinary courts. One, it's time. I mean, in the same way that for reasons that Robert explained, in terms of time and scale, information is totally different, and that means that asking for ordinary courts to intervene, to prohibit content, to appeal this, to decide the decisions, will be largely de facto ineffective because the normal judicial procedural times do not fit the impact and the scale of the impact of the content in the digital platforms. And so in that way, an alternative dispute resolution system such as the Oversight Board has an important institutional comparative advantage. The second important institutional comparative advantage has to do with something that I will define as jurisdictional asymmetry. That is, in both instances, because we are talking, again, a parallel with FIFA and the sports area, we're talking with transnational bodies that basically de facto transnationally regulate certain areas, and but are then subject to the specific jurisdiction of certain courts. So Facebook will be the United States, for example. Most digital platforms will be the United States, and this creates a problem. And a problem, actual problem that becomes a problem of due process. Let me give you an example that involved actually a case that has again become popular. Francisco will know this in Portugal. Just in the last couple of days, there were two famous bloggers in Portugal that made public confidential information of the largest Portuguese club, not the best is Sporting, but the largest is Benfica. And two bloggers made public confidential information about that club that basically highlighted unlawful activities within the club. We found out, this was 3 years ago, we found out in the past 2 days that now the president of Benfica is now detained by the court for unlawful and criminal activity, in principle allegations. But what is interesting in that case of the two bloggers is that Benfica managed to get Google to prohibit those two blogs on the basis of a lawsuit that Benfica brought in the United States that Google didn't interfere about. And of course, the two bloggers that are two small individuals could not even make their position known before a court in the United States. They couldn't even afford an American lawyer. And so the American court decided the case, hearing only one of the sides of the position. And this is an example that highlights the difficulty of having a particular national jurisdiction trying to decide cases that are of transnational nature and whose interested parties may be in many different states. And so this jurisdictional asymmetry between the nature of the cases and national judicial systems pleads in favor of a system such as the Oversight Board. And therefore, that can be seen as an institutional comparative advantage. And in fact, I'm not sure anymore if it was Robert or Kate that noticed the concern in the Oversight, or both, the concern in the setting up of the Oversight Board to have members that represent the legal traditions of all part of the globe, or at least not all of them, it's impossible, but at least of several legal traditions. Now, this being said, it doesn't mean that the system is perfect, and I want to raise some questions. It's certainly much better set up, in my view, than CAS. I had a meeting with the staff of Facebook once that was setting up that was working on the oversight board, and I told them, if you have to leave with one lesson from my part from this meeting, is don't do the same thing that they did in CAS. that was my fundamental and key lesson. And I think in a good way, in a good part, the system is much better set up than CAS. The Board of Trustees works a little bit like a governing judicial body. That's the way I see it, but an independent one, and therefore protects the independence, much more independent than ICA is for CAS. So that means that the way the members are selected, everything else seems much better protected. It seems much more transparent regarding publication of decisions, the standards that are going to be used. CAS has almost no transparency, no criteria, no standard for what is published, what is not published, and therefore no way, for example, of making them accountable for the consistency and the coherence of the different decisions that they are called awards in CAS of the different panels. And much better regulation of conflicts of interest. There's no regulation whatsoever of conflicts of interest, very weak in CAS. And the code of conduct of the oversight board, in my view, if it will be well enforced, and I have no reasons to believe that will not be the case, I think plays a much better role in that sense. This said, there's still some questions in my view. One is the renewal of terms. I have doubts, and when I had that meeting, I had tell them my suggestion for you will be one single term, longer term. So renewal of terms always make me uncomfortable. But I did notice that it appears rather automatic, only exceptional, and for breaches of contract, I assume that when people will not write the decision that were supposed to be drafted by them, and the fact that ultimately it depends on the board of trustees that is itself independent, I think gives me much more comfort. I probably would have preferred non-renewable terms, but I think that the way it's set up, it's reasonably protects the independence. I think the three most problematic things are, on the one hand, limited number of cases that will increasingly lead to tensions on why do they select some cases and not others. Second, and perhaps the most problematic one in my view, is that Facebook seems to have a veto power on cases to be reviewed. That's the way the rules seem to be set up, because they say, and even in the Al Jazeera, they say that they send it to, and Facebook confirmed that the case was eligible for review. I see Robert and Kate shaking their hands. They will be able to say, but the rules does say that Facebook can deny the review, one case to be reviewed, if it fears adverse governmental action. That is in the rules. So it needs to invoke that. But of course, fears of a adverse governmental action is a rather problematic standard to be used. And that's where I think this is something complicated. It's more one of the more controversial aspects. And if it will ever be used by Facebook, I think it might create one of the weak points for the board. Let's see how that happens. And the second most problematic issues, in my view, is this tension between being both adjudicatory and advisory. So it's both seems to be conceived as a board that will adjudicate and review the standards and the implication of the standards and the application of the standards by Facebook. But on the other hand, it seems that it is expected that it will itself develop such standards and at least propose them to Facebook. And the oversight board, in my view, in Trump, showed its own lack of comfort with this ambiguity in the way that Kate said, by clearly stating, no, we're not here to replace you in setting the standard and deciding the sanction. We are here to review whether the sanction that you will apply conforms with the standards that you have yourself set up, and in light of human rights. They will interpret those standards in light of human rights, what seems in my view, by the way, a very positive development. Now, and I have to be shorter now. I apologize if I'm overextending myself. I'll be much short in the two final questions. As I said, platforms will increasingly be susceptible to be liable for content, at least in some legal jurisdictions. When regulating and setting up these obligations, but there is legislators, or reviewing compliance with these obligations, that is either by regulators or courts, the interesting question that in my view will emerge is whether this, both the legislator in deciding the obligations that will impose on platforms, and courts in enforcing those obligations and reviewing the editing of content by platforms, if they should take into account the existence of an oversight board, such as the one of Facebook. My view is I think that they should. And this is something that I've actually argued for CAS, if CAS was not what it was. I argue that there should be much more deference. There should be deference in sports only if CAS will conform with certain standards. And I think that there's a very interesting model, you will not be surprised to hear, to be used in this respect, and it's constitutional pluralism. If you think about the relations between national legal orders and the European Union legal order, for example, you can draw inspiration in that respect to what you see in this area. That is, the extent to which legislators or courts should defer to content curation or content editing by digital platforms should depend on the institutional and procedural systems that platforms have developed in order to review and decide on content, and not only to depend on the specific decisions on content. So the more digital platforms will set up institutional systems that are that justify trustworthiness on the part of regulators or on the part of courts, the more they should defer to the decisions on content taken by platforms. I think this should be one of the way forwards, and this leads me to the third third question. In my view, this is an approach that actually the legislators could develop in terms of being applicable and imposed on digital platforms. I too agree with what you all have said so far, that to a large extent, it is from constitutional law and not from private law that we can draw and that we should look into the appropriate way of regulating digital platforms. I don't think we can conceive them as simply a provider of service whose relation with users is a private contract. I think they, but at the same time, I think that they are not simply a public space and non-intermediated public space. I think that they are both editors and regulators of the public space. And this tension is a complicated one for them. And to a certain extent, what Facebook is trying to do is to say, okay, we remain the editors, but we transfer the regulatory role to the oversight board. So whether the oversight board should be the regulator or whether the regulatory role should be another one, and then you create one that reviews the decisions of regulatory body, it's another question, might be a step forward in the progress. But that's what I think Facebook is trying to do. Now, how should public regulators, how should legislators deal with this ambiguous nature of the digital platforms as editors and regulators? I think that the best way to deal with it is by an approach that focuses much more at the level of the architecture of the digital platforms. And that's why I think, and this is the link with the previous question that I was mentioning, that I think that actually the experience of Facebook might be taken into account by legislators, and I'm thinking here by the European Union legislator, in terms of imposing on digital platforms to, instead of assuming that we will be able to review every decision on content of the digital platforms, that we should be much more focusing on imposing on them a procedural and institutional mechanisms that safeguard certain constitutional principles on how they will edit and regulate content on the digital platforms. And that being the case, final point that I want to add, I think that approach can then also be used for other dimensions of the role of the digital platforms. I'm thinking in here, for example, of imposing principles of architecture in terms of the structure and the pluralism of the algorithms, for example.
Thank you so much, Miguel. This was a very comprehensive analysis of the decision and of the oversight board. Fantastic. I retained 4 points from where you said, in standard of due process, it seems that the oversight board somehow fares actually fairly well when compared to other bodies. And FIFA, we have discussed this numerous times, but FIFA is always really an interesting kind of benchmark to assess good governance and due process. But then again, the question, second point, on the nature of the body, the tension between adjudicating the law, creating the law, but also between publishers and regulators of the published space of the public sphere. This is something that I really think we should discuss in the Q&A, because it's just in every speaker is somehow referring to that. And then the two final points on regulators going more after substance than going more after procedure than substance, and I wonder how that would somehow connect to Kate's point on injecting democracy and democratization from the inside, whether we could somehow foster that democratization through procedures. And the final point is that Sporting is the best football club in Portugal, and that's an essential thing to remark, which I absolutely agree. Finally, last but not least, my next speaker is also a former UI alumnum and also a good friend of the UI. Mateusz Grokowski obtained his PhD at the Institute of Law Studies in the Polish Academy of Sciences, and received, and I must say this because it's a big prize, the prize for the best Polish dissertation in private law. He is a private lawyer, so it's a fantastic leeway to what Miguel just said and how private law can approach the phenomenon. He holds an LLM from, not surprisingly, Yale Law School, and is also an affiliated fellow at the Information Society Project at the Yale Law School. Currently, Mateusz, I believe you're probably finishing, Mateusz is an Emile Noel Fellow at NYU at the Jean Monnet Center, and also a Senior Research Fellow at the Max Planck Institute for Comparative and International Private Law. Mateusz, it's really a pleasure to welcome you once again at the UI. We look forward to hearing your side, your private law side of this question. I think it will be very meaningful for all. Thank you very much. The floor is yours.
Thank you, Francisco. Welcome, everyone. And well, let me start from saying again that I'm very grateful and very, very happy to be a part of this panel for two reasons. Because I'm coming to this topic from a partly similar and partly different ground than the previous speakers, because as you said, I'm a private lawyer, but and let's say my academic origins are in the classical contract law theory. However, right now the bulk of my research agenda concerns the use of contract and the idea of contract and some private law mechanisms and tools in order to regulate or self-regulate the digital sphere, both in terms of, let's say, economic matters, but also in terms of social matters, such as freedom of speech and expression and exchange of information. And here I am especially interested in the emerging role of platforms, such as Amazon, Facebook, eBay, and the others, as the new kind of regulators, as Jack Bolkin would frame it, as the new kind of sovereigns on the market and in the society. And I think from this perspective, the FOB, the Facebook Oversight Board, is a particularly interesting and particularly thought-provoking phenomenon, which also gives a lot of material for analyzing and understanding how and to what extent the private entities, private actors, such as platforms, can nowadays perform or take over some regulatory tasks in social and market matters, and to what extent they can either compete or substitute states in performing such tasks. Let me share my screen, because similar to Professor Maduro, I would like to make 3 points, but I would like to, maybe it will be better if I frame them briefly on slides. But before I move to my first point, I would like to maybe for the sake of introduction say one more thing, because the previous speakers were trying to frame the issue of the Facebook Oversight Board from mostly the perspective of constitutional law, and mostly from the perspective of the let's say American discourse over this topic. However, Professor Maduro was also referring to the European Union discussion and European Union issues, and I would like to partly follow this thread and to think more deeply about what the Facebook's Oversight Board can signify from the European perspective, from the perspective of EU law, and from the perspective of the EU approach towards freedom of speech and towards, let's say, the public-private divide in regulation of the digital sphere. And here comes my first point, which I would like to make about the FOB, which is something unsurprisingly concerning the legitimacy and democracy deficit or democracy legitimization question of the FOB. Namely, the question to what extent we can think about it as an adjudicatory body that enjoys some sort of legitimacy, some sort of democratic mandate in order to decide on sometimes very profoundly important issues, such as the Trump case we are focusing on today. And here, the question of legitimacy can be understood in 2 ways. And of course, one of them, and this is something we've been talking about a lot before, is the problem of appointing the Facebook Oversight Board, the problem of selection of the people who are, in fact, adjudicating the cases submitted for the board. But secondly, there's also a thicker and more, let's say, ample understanding of the legitimacy and democracy that's at stake here, which is the question, who is in charge of defining what is freedom of speech, what is freedom of expression, and what are the constraints, what are the borderlines for exercising this freedom in the democratic society. And of course, as we all know, this task, as many other tasks in the digital public sphere, which are now taken over by to some extent by private entities, has been traditionally reserved for the state, for some democratically appointed authorities, officials, whoever it might be, a judge, member of the executive power, of the legislative, and so far and so on. Here, of course, we have a completely different kind of questions. And these questions are not very different from the formal point of view, because when we think about the economic or social history, we can come across many examples where some privately set bodies, some private courts, private boards, whoever it might be, were deciding on some matters, for example, concerning economic exchange, concerning particular social or economic freedoms, and so on. However, here, when we think about Facebook, the difference is not in terms of the form of adjudication, but rather in terms of the impact and in terms of the size, because most of the cases decided by the Facebook Oversight Board have not been limited in terms of their scope only to the particular act of speech, the particular dispute between Facebook and its user. But in most cases, the impact of the decisions made by the FOB is much broader, and it reaches much further away than simply decision on how the particular argument between Facebook and the user slash client should be resolved. So in so doing, of course, the Facebook Oversight Board sets particular standards for the freedom of speech. And of course, in so doing, it is also exerting the power to exerting impact on the understanding of freedom of speech, for sure, for the entire Facebook. But perhaps, and of course, it's quite early to say how far-reaching this impact might be, but for sure, there will be some spillover effects of the decisions of the Facebook Oversight Board over the other social platforms and the other parts, the other domains of the digital social discourse, digital social sphere, also beyond the Facebook as such. And also thinking about the democracy and legitimacy, and also thinking about this problem in a more transatlantic perspective. I think it's also interesting to notice that let's say, division between the understanding of fundamental rights in the US and in Europe, which mostly relates to the division between, let's say, acknowledgement of the so-called horizontal effect of fundamental rights and vertical effect, can be also quite telling for the further development of the discussion over the Facebook Oversight Board in Europe. Because, and here comes, I think, the most interesting contractual perspectives, because as long as we think about fundamental rights, including freedom of speech, as a right that can have the horizontal effect, so it can be applicable, directly applicable to the relationship between Facebook and its user, which is a purely contractual relation, of course, based on the terms of service drafted by Facebook, but which, of course, are a contract in the formal sense. Then it opens a very, very broad cluster of problems concerning, for example, to what extent freedom of speech and guarantee of freedom of speech can be understood as a part of the contract performance, to what extent civil courts that adjudicate contractual disputes should take into account freedom of speech as one of the premises for the decision, and so on. So this is all about my first point. And now the second point is about something I, for the sake of this presentation, framed as the California effect. I hope most of you are familiar with this celebrated book by Anna Bradford, the Brussels effect, which basically tells how and to what extent the EU law has some transnational impact, and to what extent acts such as GDPR are framing the global social, economic, and legal domain. And I think in terms of FOB, we can think about, and indeed some of the analysis of the Facebook Oversight Board I read, mostly the American analysis, are trying to at least primarily approach this problem. Is the question to what extent the understanding of freedom of speech and understanding of the constraints to freedom of speech developed by the FOB can in fact operate as a sort of a vehicle, as a venue for transplanting, or let's say imposing, particular understanding of freedom of speech onto the other domestic national jurisdictions outside of the US. And so in other terms, to what extent the spillover effect of the FOB can reach not only to can embrace not only Facebook, or can embrace not only other private entities such as other platforms, but to what extent it can also transform the understanding of freedom of speech as such. And here comes the other point that has been already made by a few speakers before, which is the composition of the board. And of course, Facebook is trying to, at least from what has been declared by the company, is trying to make the board possibly pluralistic. And first of all, in terms of the jurisdictions from which the members come from, but also in terms of the, let's say, overall political, institutional, and cultural experience they take with them. And for sure, the kind of, let's say, creation of the new understanding of freedom of speech by the FOB is not merely the legal dispute. It's also to some extent that clash or struggle between various cultural backgrounds and various political understandings of this freedom. However, again, I think it's very interesting to think about FOB as a sort of a new and very creative, very unusual source for establishing a new, perhaps at least to some extent, global and transnational understanding of freedom of speech and freedom of expression, and the constraints to these values, to these freedoms that are admissible in a democratic state. And last but not least, something that Professor Maduro has already briefly referred to. So the Digital Services Act, which has been proposed in December by the European Commission, which is now operating as a sort of a flagship for the new approach of the EU towards regulation of the platform economy, of the discourse on the social media. And here, of course, it's still a proposal, and it's still awaiting its, let's say, final political sanction. But what we can say from the Digital Services Act, and what we can say about especially the general regulatory attitude of the European Commission is, first of all, that the Commission is trying to clearly regain or reclaim the control over the digital market, also including the issues related to freedom of speech, related to fake news, related to content moderation. Secondly, this act also tries to address the phenomenon of some privately established adjudicatory bodies, including the FOB, which of course is not directly mentioned in this act, but this is clearly one of the possible out of court dispute settlement procedures that fall within the scope of the DSA. And here DSA on the one hand is trying to very clearly emphasize the individual autonomy of the platform user to choose the dispute resolution scheme that fits the preferences of this individual user to the highest possible extent, and also allows to completely opt out of such privately made system and go directly to a court, which perhaps may to some extent hinder the operation of some systems of dispute settlement established internally by Facebook or possibly by other social media platforms. On the other hand, however, the DSA also proposes the procedure for the official public authentication of such internal private dispute settlement schemes. And in these terms, probably the Facebook Oversight Board might be one of the possible subjects of such authentication. And again, it's quite hard to say what might be the consequences at this point, but for sure the European Commission seems to be quite open for developing various schemes of cooperation, of shared responsibility between state courts and some privately established adjudicatory bodies. And finally, DSA seems to be quite scarce in terms of remedies, also remedies for example, fake news or for some defamation on social media. And here, perhaps the major burden will be on the member states, which will have to devise or implement their own systems of sanctions of remedies, which again may possibly act as the possible advantage for some centralized adjudicatory bodies, such as the FOB. And de facto, in the situation where there will be facing a plurality of approaches amongst member states of the EU, such centralized, privately made schemes can play an even more important and more, let's say, definitive role for both in terms of remedies and in terms of setting the common joint understanding of certain concepts, such as, again, the freedom of speech and the constraints to it. Thank you. This is all for my presentation. And again, it was a pleasure to speak to this auditorium. Thanks.
Thank you very much, Mateusz. Very interesting perspective. And you touched upon something that I think originally Robert had already discussed, but briefly, which is this kind of exogenous effect, this kind of spillover effect, or this kind of legal transplant, whatever we want to call them, that it's happening, this California effect. And I think people are now studying it more and more. And today, actually, at ICON, there was one very interesting presentation just on this. But it's interesting again to see how the FOB might actually work, not only as a way to adjudicate individual disputes, but moreover actually define standards that go way beyond the private realm of Facebook. Professor Post wanted to just answer a couple of these remarks that were made. So, Professor Post.
Thank you, Francisco. I just want to make 4 quick points before we open it up. And I think it's important to stress them in this context. So the first was Miguel's distinction between a court and a regulator. And I want to say this is a very civil law understanding of what a court is. You know, it takes a dispute, it settles a dispute. In the United States, where courts desegregate police departments, where courts intervene and reform prisons in order to prevent cruel and unusual punishment, we have a different model. We have an additional model of what a court is, not a private dispute settlement mechanism, but an institution which reforms and reconstitutes other institutions. That's what I was referring to when I talked about the public law model of adjudication. And in my view, my personal view, unless the Oversight Board understands itself in that model of a court, not of a regulator, and it's a way of fusing these two in the American jurisprudence, it's going to have a very hard time accomplishing the purposes which it needs to accomplish to be successful. Second point, very quickly, we were talking about the relationship between state regulators and the institutional regulation of private parties like Facebook. So if you take, say, the number of posts in any given year on Facebook, I don't know what the number is, but it's certainly in excess of 1 billion. There is no way in the world that the state can police this, the state as an institution. So it's going to have to defer to institutional forms of self-regulation by the platforms. And indeed, how you content moderate at scale, that is to say, what part of it is AI and computer driven, what part is people driven, and how you have people driven at that scale. This is, I think, a central problem that will be facing the Oversight Board and indeed any regulator. My understanding is that the right to be forgotten in Europe is enforced in any event exactly this way. That's why Google set up its subsidiary dispute settlement mechanisms for the right to be forgotten. And you think about it from the state's point of view, it has no choice, really, at this kind of scale. Third point, that came up in several speakers, which is how is the Oversight Board going to be legitimated? And we see the democratic metaphor a lot. I was interviewed by a researcher who said, why aren't the stakeholders deciding these cases? Why is the Oversight Board deciding the cases? I think one has to be very careful with the metaphor of democratic legitimation in the context of the Oversight Board. The Oversight Board governs 3.2 or more billion people. There is no state that can provide legitimacy. There is no institutional demos at that scale at the present time. So the feedback loop to think about that as democratic is, I think, to misunderstand the way in which legitimacy has to be created at a global scale, a really global scale. We don't even think this way, but this is actually reality now for the virtual public sphere. So what are the forms of legitimation? On any account, it's going to be elite legitimation. It's going to be a legitimation through competence of various kinds. And what we have to think about is how that works. But to imagine this in a political register, like there are democratic voters or the users of Facebook vote on whether or not, and have those kinds of people, I think needs to be seriously interrogated. So I'm putting a word of caution in for metaphors of democracy as distinct from rule of law and forms of legal legitimation that happen through competence, through elite imposition of legal institutions which carry their own competence, just to make people think twice about that. And the fourth point, very quickly, about the veto that Miguel mentioned. Facebook has reserved the right not to be forced to do anything which, in its view, is illegal under the positive law of any state. That's what I think the provision that you were referring to, and I think that's not quite saying if it's going to cause political difficulties. What they were meaning is we can't be forced to do something that our lawyers advise us is illegal, and that I think makes sense as a contract matter.
Thanks a lot, Professor Post. I think the connection between legitimacy and scale and size, and I do apologize because I kind of misinterpreted what Kate said, or I just pushed it a bit too hard and saying,
no, I shouldn't have said that. Yeah, I shouldn't have said the word. I get a little, sometimes I'm just like, wasn't thinking. Robert is completely correct. I used to refer to this as democratization, like early in the project, and like democratic legitimation, and it's not. It is like about building participatory mechanisms. It's about creating accountability, and it's about establishing rule of law and process. And like, I think that a lot of times in a colloquial way, like democracy gets like wrapped up in those ideas, but it is not democratic from a demos perspective, as Robert said.
Thanks a lot, Kate. So we have already 3 questions and 1 on the chat. I will first give the floor to, I will collect the questions because I think it's easier because we don't have that much time. So I saw Nicholas first, then Moritz, and then Giovanni. Please just be brief in your questions, and then we'll get another round of answers.
Thank you so much for this fantastic event. It has been so interesting. I also have a question relating to legitimacy. I think we might say that there are mainly 2 ways to legitimize the power of courts or of the oversight board. The first way relates to the composition of the board, the processes, and the conditions in which they operate. And I think here the speakers seem to agree that the oversight board did a fairly good job. I think the second way that can legitimize the power of a court is the way that this court or the oversight board basically works with the law, the way that it interprets the law, the way that it reasons. To make an example, I mean, Professor Maduro knows this better than anyone here, of course, when looking at the European Court of Justice. I think it is rather obvious that this fantastic and great and important role that the European Court of Justice has played in the integration process of the European Union also depended a lot on what we could call its meta-teleological interpretation in a way, like this effet utile arguments. The way that it worked with the law really shaped what it did, but it also was the foundation to really attack the legitimacy of the court, because people were saying, it's going too far, it's really shaping the European Constitution in a way, and this is not what it should do. It doesn't work with the law in the right way. And I think at the Supreme Court, we maybe have similar battles between originalists and more progressive interpretations. And so my question here really is, what do you all expect from the Oversight Board in this regard? How could its reasoning contribute to its normative legitimacy? Thank you.
Thank you, Nicholas. Moritz?
Yeah, thank you very much. I'm going to be very brief. Isn't the reliance on human rights basically a wave of goodbye to participatory legitimacy? Because in constitutional law, we see it's, I mean, like, it's a debate we had for decades, that once we jump on the right train, we have democratists or like majoritarianists complaining, and if we do it the other way around, we have the other side complaining. And of course, human rights at the moment carry a high degree of legitimacy, are accessible, and it's not so messy to apply them because they're already there. They have the UN, and everything's perfect. But still, I wouldn't, like, perhaps that's me being a young idealistic person, but it's still, there's some value in participation that actually is based on some kind of demos. And of course it's new, but I mean, like global human rights law, there's also something quite new and quite revolutionary that we would have deemed illusionary 150 years ago. So I would kind of push back a bit on what Robert said on this. We're simply not there demos wise. Yeah, definitely we have to improve the concepts. But if there's an institution that can do that, then it is Facebook. And if we can introduce something like a Supreme Court global for 3.2 billion people, then we can also, of course, introduce participatory mechanisms. I mean, or why not? That's my question.
Thanks a lot, Moritz, for challenging a bit and raising the debate. Giovanni, now I think we'll go with Giovanni, and then I will do another round after the answers.
Thank you so much. And of course, I would like to join this kind of a round of thanks, because it's been really interesting to hear from you. I have actually two very brief questions and a comment generally. I mean, we've seen how this Facebook Oversight Board has been a real interesting experiment, especially for human rights, at the global level, especially even if we think the distinction between human rights and fundamental rights, for constitutional law. But still, the question is: could the board be, an important way to overcome a lot of deadlocks in the field of human rights law, and especially human rights, where we do not have every time courts or institutions that can really enforce this right? So can the board be an experiment even for states and public actors, to try to think a little bit outside the box, especially when we deal about digital rights and global constitution? So this could be an idea, maybe to think, maybe it's more a trigger for states rather than maybe a threat. Maybe it's a threat, maybe yes, but also could be a trigger to, in a way, reframe traditional institution, the role of traditional institution, the cooperation between public and private actors in the digital environment. So this is a question for all of you. The second question is about, what about the competition, between the rationality of the Facebook Oversight Board and new other potential social media accounts, generally speaking, that could rise in the next future, also because we have seen how other social medias and this form of private judicial dialogue, in a way, this kind of interesting, it's not a label, but it's just, to discuss this point, because it's interesting to see whether the Facebook Oversight Board will become a model, and maybe other actors will maybe join the trust. I don't know. We don't know actually whether it will be the future, or maybe actually there will be a competition, a fair competition, or a cartel, maybe, between these actors. And they have also another comment. This is very interesting when we talk about in all the presentation, the public-private divide, the role between the intersection between constitutional law and private law. What I think is that, when we look especially at Europe and the US, because we have this transatlantic debate now in this panel, so it's so interesting to see how, the two sides of the Atlantic looks at the same problem and actually use very different constitutional instruments to address with that. And I say so because in a recent work that I made on content moderation, especially in the US, we try to look at how contract law, and I can share then with you the link on the chat, how contract law could solve and provide a kind of bottom-up approach to solve some of the deadlocks that constitutional law face when we address content moderation in the US, while in the EU it's pretty much the opposite in a way. It's the constitutional law is really an engine for the positive obligation of states in the regulation. So this is just two questions and a comment. I'm happy to share with you this work on the chat. Thank you so much again for this amazing presentation.
Because I think a complex set of questions, but we'll try to. I think I will give the word first to Kate because she has spoken less than the others. Then we'll progress to Miguel Maduro. Then I'll give the word to Mateus, and then we'll finalize with Robert. There was a question directed at him, so we'll have a bit more time to answer that. So Kate.
Yeah. So okay, three absolutely phenomenal questions, but I think where I do the most value add is in Moritz's question. So this was fascinating. Why human rights? Like, why did they pick this kind of model? Like, as you just pointed out, this is actually kind of in some ways at odds with a participatory type of model going forward. So I will just say that the reason that they, in this perfect kind of circle of events, the reason they picked the human rights model is because in the participatory process of setting up and surveying stakeholders about what they wanted to see in the oversight board, and was overwhelmingly like a commitment to internet and a use of international human rights law. So ironically, the participatory mechanism of the process for the first 6 months of setting up the oversight board told them use human rights law. There have been many people who have said from the beginning that this was not going to be a feasible type of way of doing this. I think that many people said choose human rights law because they thought that human rights law could be the substantive standards that that basically Facebook was hewn to, which, as I think all of us can acknowledge, is just not how we can set a group of speech standards for the entire world, even though they might work in a certain type of framework for a certain set of cases, but in the 3.2 billion user model, like that they're just not, it's not possible. So I think that that's exactly correct. And I think that to the extent that I can answer the kind of the other question also about kind of how some of this came about and where it's kind of going in the long term as a model for other actions, there is a very, and I think that this is a slightly controversial, this is my reading, this is also comes from a number of conversations with the people who drafted the language of the charter and the bylaws and the trust documents, which is that there is room in the trust documents, which are very, very key and the most I think I would say the most significant, even more significant than the charter. There is room for the trust to set up in future action should the board think that should they think that it is in the board's interest, is in pursuit of the board's interest in preserving the purpose of the board, to set up a participatory process or some type of more participatory group, more of if you wanted to think of this as an agency, some other type of agency that was more focused on participatory stakeholders and having those other groups. So I think that you have to think about this truly in an institutional capacity, in an agency capacity, which it is at odds with kind of the transatlantic, opposite kind of very opposite constitutional models. It's unfamiliar. I was telling Robert earlier that whenever I came over to present this, when I first decided to start presenting this in Israel and UK and Germany, I just was I kind of presented all of it, and there was really a true kind of what is this? What is going and I was oh, am I not explaining? No, I just was explaining it it was a very American kind of formulation, both in how it was being conceptualized by a California-based company that was doing this, and unfortunately or fortunately, I am an American researcher and I have my own priors, and so there was a lot of kind of that kind of got baked in. But I think that it's useful to kind of try to triage how this is working, and make it clear that there can be kind of that we can really, as we're kind of struggling for how to understand this model and we're creating a new one, that we can really kind of have some creative approaches and not be limited by either formulation from in a Europe sense or from an American sense, and maybe or from a public sense and a private sense. So I really think it's kind of the reason I love this work is it's an insanely interesting time to kind of be kind of working on these issues, and it's an incredibly creative time to be a lawyer and an academic. So I will leave it there, but thank you so much.
Thanks a lot, Kate. Miguel, if you'd like to comment.
Yeah. I'll start by reacting to the questions. Go back to the question of the Facebook veto or non-veto right, and Robert is true. I mean, it does say that it is content that is unlawful in a jurisdiction, but my question is, it doesn't make that assessment on what is unlawful dependent on a previous decision of a court of a particular jurisdiction, and to a large extent, any of the decisions that I think the Oversight Board will take will involve things that may be considered unlawful in one jurisdiction or another. So basically what this provision does is ultimately allow Facebook to preemptively say, well, we believe that this is unlawful in a jurisdiction, and that this may lead to a governmental action that is detrimental to us in a jurisdiction, and therefore you cannot decide it. It leaves open that possibility, and that leads me to I'm not sure that's going to happen, but as I say, the possibility is there, and this might turn out to be a problem and a source of tension with the oversight board. And this leads me to one of the questions that was posed actually by both the question of human rights and the question of the legal reasoning, of the extent to which the board legal reasoning might be an instrument of legitimacy. Because one of the interesting aspects is that we are all expecting the board to develop a form of legal reasoning supported on human rights, and that indeed what the board seems to say, that will fit therefore with a kind of international standard that the board will develop. But at the same time, Facebook will be confronted with the specific laws and assessment in particular jurisdictions. How will the board be able to legitimate itself developing standards that we all expect will be standards that Facebook will enforce across the board, and at the same time, Facebook still be confronted with adapting that to specific jurisdictions that may have very different views on human rights, and in some cases even oppose human rights. And that tension, I think, is something very interesting, and that may end up undermining the role of the board, or may not, but it will definitely, I think it's worth seeing how that tension will be resolved. Because on the one hand, Facebook has to decide on content with respect that is posted in a particular jurisdiction, or in light of the fact it is being read in one or more other jurisdictions, and in light of the standards of those jurisdictions. And on the other hand, the entire construction and intellectual conception of the board and our own expectations of legitimacy with respect to the board, as this discussion highlighted, is that we see the board as an instrument to develop international standards that are complying with human rights at the international level. The extent to which we might be generating expectations on the board that the board will not be able to fulfill and Facebook will not be able to effectively implement might turn out to be a problem in the future. And this leads me to the other aspect, that is the question of on the one hand, democratic legitimacy, and on the other hand, what exactly is the role of the board? From this discussion, I'm more convinced now that maybe the system should distinguish between a policy advisory role that will be more participatory based and democratic based, and a real adjudicatory role. And I'm sure, I mean, Robert explained very well how courts can also take the judicial decisions that adjudicate but provide policy direction and shape policies, but it's still different from giving an adjudicatory role a specific task of issuing certain standards and policy recommendations. And I wonder the extent to which that may not be something that will have to be revised by Facebook in the future, and maybe creating two chambers or two bodies of different type.
Thanks a lot, Miguel. Very interesting, this clarification. And there is, of course, there are many cases in international law where such division is made, and it is possible to be made. So we had two more questions in the meanwhile. I'll just try to summarize them, and then I will give the last word to both Mateusz and Robert. So Nish asks, when does information sharing becomes an infodemic, and when that happens, that change things, and could somehow the FOB play a part in these sort of infodemic scenarios? And then there was another question, Facebook's power competence not to answer certain questions submitted by the board. So just a small clarification on this. So first Mateusz, and then final words to Professor Post.
Okay, so should I try to answer to those two questions, or?
You can answer all of them. I mean, you can cherry pick. Of course, we have about if you can bear with me 5 more minutes, we will just finish it.
Sure. No, so I will try to keep myself very crisp on this. Well, I'm not sure if I can answer all of these all of the issues raised in those two questions as at the end. But first of all, when it comes to the global regulatory board like WHO, yeah, I think such ideas for regulation of the platform market are constantly looming on the horizon. Maybe not a WHO for platforms as such, but at least WHO kind of entity for some parts, for some sectors of the platform industry. For sure, this is something that is discussed right now, but personally, I'm not a strong believer in this way of regulation. I think instruments such as FOB, so something coming from, let's say, inside out, the platform industry is much more promising and much more feasible as a tool to address the social and economic problems in this sphere. Secondly, when it comes to the question of Giovanni about contracts and contracts as a tool for, let's say, overcoming some gridlocks that are faced by the constitutional law and by let's say, some more public law-based regulation. Yes, I absolutely agree with you. And here we have it was not me, and here we have a very, also a very, I think, telling divide between the US and Europe, in the sense that I think in the European approach towards contracts and towards, let's say, thinking about contracts vis-a-vis regulation, we are much more used to thinking about contracts in a more instrumental, but potentially instrumentalizing way. So we are much more, let's say, we can accept much more in terms of thinking about contracts as a tools for example, pursuing some public oriented goals or towards regulation of society or market. So as opposed to the American approach towards contracts, where, let's say, let's say most of such traces is much harder to justify and to explain within the framework of the American legal order. Yeah, so these are my let's say, two main points I wanted to make, and the last but not least one is, again, this democratic legitimacy. I would like to sincerely thank you to Professor Post, because I think the issue he raised here is extremely important. It's also extremely important from the perspective of, let's say, thinking about the way of legitimizing the sets of rules created by platforms through terms of service, through various user agreements, yeah, I think this, let's say, departure from the purely democratic oriented thinking is a very interesting and a very thrilling way of framing this problem. So thank you.
Thank you, Mateusz. And now we finish where we started with Professor Post's brilliant remarks. Thank you very much.
Yeah, the remarks of the person who was around before the internet. So I just make 2 points. The first is that many of the remarks, in particular those of Giovanni and what Miguel said, stem from the following tension. The virtual public sphere, because of the way information is distributed on it, is a universal public sphere. But law tends to come out of jurisdictions which are divided into political states. So there's a tension between a universal virtual public sphere and the jurisdiction and the authority of local states. This is not a problem of the Oversight Board. This is a problem of the meeting of two different social forms. And my suspicion is it will be negotiated in the polyphonic way that Miguel has written about, for example, the way that the tension between European law and the law of the European nation states are negotiated in a very messy, complicated dance between the two of them. And I suspect that's what will be happening here. And by the way, the veto provision, Miguel, is I don't read the veto position to say if it's illegal anywhere, you can stop it at any time for any post. I read it to be if it's illegal in the jurisdiction of the user who posted it, then we're going to make those adjustments. So it was, the conflict was much narrower than the way in which you stated it. But it could be read in the very broad way that you read it. I just don't think that was either the intent or the way it's operating or anything like that. That's the first point. We have a tension here of two social structures. And that point is relevant for the second point that was made by Niklas and by Moritz, which was the tension between different forms of legitimation. And in particular, Moritz said, well, what about the participatory form? In America, I'm Mr. Participation. That's what I write about all the time. But participation is at root legitimizing because it's political. So you need a political frame for participation to do the work of legitimation. And in here, participation is different than, say, consumer exit or various forms of aggregation that come out of the market. Market doesn't legitimate, market does something different, but legitimation and participation is a political metaphor. Politics requires an agora, it requires a forum in which you recognize a demos that is self-recognizing. And for whatever reason, it doesn't presently exist. That's not to say it can't come into being. And my guess is if you have an institution that answers to a universal public, that public may acquire political overtones. And so participation may be a form of doing it, but it's not now. That's all I want to say, most definitely now. Just like the UN is not a universal form of government, so there can't be a universal form of government out of Facebook. So we have a disparity between a virtual public sphere and a universal demos. And that means the legitimation has to come through other mechanisms. So one is you buy out elites. You get elite participation, which we call stakeholders, and you make sure that elites in various possible jurisdictions buy in, and you have some compromise. And different one is the legitimation of competence or reason. This goes to Giovanni's question. I mean, there is a large literature on how governmental agencies can legitimate themselves by being competent. What does competent mean? It improves the lives of those they govern. And so that's a well-recognized root, large literature on that. And something like that is what is going to be, is what has to happen, I think, at least at the beginning, for the Oversight Board, which means it's going to rest on the form of its judgments and the quality of its judgments and the quality of its reasoning, which is why the way in which it handled the Trump case is so important, because it did have, I think, in my personal opinion, the attributes that Kate gives to it. I think she's right in understanding it the way she does. And it was a very professional job. It was a job that any court would have been proud to do. And that matters in this context when we speak about the term of legitimation. So I just wanted to end on those 2 notes.
Thank you so much, Professor Post. And we are now 7 minutes past the time. I apologize for that. But I must say that it was really a personal pleasure for me to moderate this session. I have 1,000 questions, 1,000 comments. So it was really an exercise of self-restraint to just moderate and say nothing. But I've learned so much. The comments we've been getting in the chat testify to that. People were really engaging. I thank you very much. We will continue our works here at the Tech Cluster at Digital Public Sphere. I hope we have more opportunities to have this kind of really profound intellectual discussion on the future of technology and the law. I wish you a fantastic weekend, and we will meet again very soon. Thank you very much, and have a good weekend.
Bye-bye, everybody.